Professor Wes Porter, criminal law. We're talking about topics in the beginning of criminal law, particularly parts of crimes. And we spent some time talking about the act that might be required, the actus reus, the mental state or guilty state of mind that might be required, the mens rea. And we're going to talk about a narrow topic right now, causation. And causation is a topic that only applies to certain crimes, namely result crimes. And it's not as big a topic as it would be in torts, where you're analyzing it in every single negligence issue. Here's where it fits. If it fits between the actus and mens rea. If it's a conduct crime, causation is less of an issue. It's not even something that you would discuss in a conduct crime because it directly modifies the mens rea, someone who intentionally took. That is the social harm that we're trying to prescribe, so we wouldn't even discuss causation. But with a result crime, there might be an act that's taken on one day, and then the result could be death, could be serious bodily injury, could be some other result that we're trying to prescribe, happens at some point later, or has other things that happen in between it sequentially. So we're trying to figure out whether the act that took place sufficiently caused the social harm. Here's the key things that they'll spend some time on in class. Remember, it's going to be result crimes only. Result crimes is the minority of crimes. Most of them are conduct crimes because you'll be able to look at the statute. You'll be able to think about the common law elements as here are the specific ones that we're talking about. Here are the specific conduct that's prescribed. So we're looking only at result crimes where it's a little more any conduct, any will, muscular movement, any act that brings about this harm. And I said the most popular one is homicide. So we're essentially saying, did this act cause this harm? Obviously, if we're charging someone with a homicide, if we're charging someone with a serious result crime, we want to make sure that whatever act they took, even with a guilty mind, was it the cause? Was it the causation in fact, which we know was it the but-for cause? It wouldn't have happened otherwise. And we also have to evaluate whether it was the proximate cause. That is, was there something else that happened in between? If I take that same analogy I've been using, I hit someone with a 2x4 over the head, and then eventually, a week later, it brings about serious injury, it brings about death. Well, I'm going to be saying, does my act, hitting them with the board, sufficiently connect to? Did it sufficiently cause that serious bodily injury or death? Or was there something in between? Did the person go to the hospital and there was a botched surgery? Did they take a car ride there in the ambulance and the ambulance got in an accident? Were there some intervening causes that we might be able to say, my action was not the proximate cause. It wasn't, or maybe it wasn't the causation in fact. If you're dealing with causation, it's almost always a defense argument. It's always a way to eliminate culpability. So I think about this in particular when I have my law student hat on. If I'm making arguments on behalf of the prosecution as to why causation is satisfied in a result crime, I'm also looking for it more specifically if I'm on the defense side and I want to say, here's an issue. Causation could be an issue. Maybe the person had a guilty mind, so mens rea is not my argument. Maybe someone committed conduct like hitting someone with a 2x4 in the head, but is it sufficiently connected? Does it really pass the test, especially to impose criminal liability? Does it connect up to that harm sufficiently? Were there other things that happen? Has too much time gone by? So those are the few issues that we'll evaluate when we discuss causation, again, with result crimes. So make sure it's married up in your notes. Result crimes, causation is going to be an extra issue that we may discuss.